all across the UK in all areas of personal legal services. We have received great feedback, reviews from our clients. We are located at Solicitors in Tottenham, on the 4th floor of the Anna House, right on top of the Victoria Line train station, with utmost convenience. We have a friendly office and provide all the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence, and conduct as part of our responsibility to uphold the rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks, Law Society Accreditation House, to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us. Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF Solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law. Victon Estates provides professional and reliable service to landlords, investors, and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stop repossession, and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride. Hello, wherever you are. Isn't it amazing to come your way every Saturday at 12 noon on this platform, Heritage TV, the Legal Hour Show with BWF Solicitors. I would like to take this opportunity to thank my sponsors, Victon Estates Limited, Eagle Heights International School, and of course, BWF Solicitors. If you've joined into this program, could you please share on all your social media platforms, and to all your friends, loved ones, and anyone you think this program will be of benefit to. If you want to contribute to this program, you can do so on our Facebook page at Heritage TV or on BWF Solicitors Facebook page. If you prefer to call me live on the program, the number is 0744 8619 711. The number is 0744 8619 711. Once again, thank you so much for joining me today on the Legal Hour Show on BWF Solicitors Heritage TV. Today's discussions, the topic is circumstances where a person can or may be refused permission to enter the UK or leave to enter council. And with me, as usual, is a seasoned solicitor with BWF Solicitors and also a partner at BWF Solicitors, Mrs. Eunice Achampong. Hello, Eunice.
Hi, Vicky. How are you?
I'm good. And you?
I'm doing well by God's grace. I'm loving the t-shirt.
Wonderful. Oh, yes. Thank you very much. Oh, thank you for the compliment. And may I also say that it looks like we are matching our earrings today.
I know, right? Because at least the hoops make me look a bit, shall I say, on point.
On point. Exactly. How has your week been?
By God's grace, it's been good. I mean, not too hectic and not too dull either. So, by God's grace, it's been a good week.
You know, when you're doing what you love doing, even when there's tiredness or stress, you enjoy doing it. You don't even feel it, and you don't even feel like complaining.
Yes. That's so true. And I think that applies to anyone.
Yeah. Right. So quickly, if you can give us any updates before
Yes, we start the program.
Discuss today's topic.
Okay. So very, very quickly, I think that last week people were asking, and then also this week people have been asking regarding the case Akisenya, which is in regards to primary carers who have Zambrano derivative rights, or those that we will say are primary carers of British children who live in the UK. And to that case, of course, the Home Office did not agree with what the High Court had given, or the decision they had given in return in regards to whether somebody who was previously a derivative rights holder and then switched to a 2.5 year leave to remain route could then switch back to a derivative rights application to then gain settlement in the UK. So, of course, a lot of people who may have been in that category because they knew that a derivative rights will not lead to settlement would have made those applications on the 2.5 year route because they thought they wouldn't be able to get settlement, or they wouldn't be able to get indefinite leave to remain if they remained on the derivative right route. And so, of course, she was one of those. And as soon as the government made an announcement in 2019 for those who are on the derivative rights route to be able to gain settlement after 5 years, she also put in the application. But of course, the judges in that case said because she previously held derivative rights residence as a primary care of British children, she could, of course, switch from her 2.5 year leave to remain that she made prior to making the settlement application under the EU settlement scheme. And so she won her case, and the Home Office decided to appeal, and it is currently, shall I say, being assessed by the Court of Appeal whether permission can be granted to the Home Office. So a lot of people who may be in this circumstance may have had derivative rights residence and then switched to the leave to remain route, which is the 2.5 year leave to remain route, are looking to see if this is something that could be for them and whether they can now apply for settlements right away. The Court of Appeal hasn't yet come up with any decision. And of course, I know it has been a few weeks since the case of Akinsenya, but we are hoping that the Court of Appeal will come with a decision in the next few months, because, of course, this is something that's going to affect quite a number of families. And so they can't just quickly make a decision on the case. And of course, those people would not be making an application where they have to pay a fee. And so we know that a consent order was agreed by both the Home Office and the legal representatives of Akinsenya to say that if the Court of Appeal makes a decision in her favor, they would give at least 6 weeks for people to put in their applications and switch from their leave to remain route to a settlement application under the EU settlement scheme. But of course, we are still waiting and we don't know yet what their decision is. And so, as soon as the Court of Appeal has made their decision, we will, of course, make that announcement and put it on our social media platforms so that people are now aware that this is what has taken place. So, yes, not everybody who has 2.5 years leave will be covered by this, because I think the main question is, if I have 2.5 years leave, does it cover me because I have a British child? Not everybody who has 2.5 year leave will come under this case, because, of course, if you look at our previous regulation, the primary carer of a British child who is saying that, of course, this child cannot remain in the UK if I am not here with the child. So the British child cannot remain in the UK if the parent is not allowed to remain here. And most children, whether the mother or the father has sole responsibility, if you are saying that the other parent is either British or settled here in the UK, then it means that for one reason or the other, the British parent may be able to look after this child, and therefore they come under what we call an exempt person. So if, for instance, you have a child and the child is British because your child's father or mother is British, then of course that means that you'll be exempt from applying under the derivative right route, because that child has another primary carer who could care for them. And many people are probably assuming, oh, so then it means that there will be only quite a few people that this derivative right stay or this derivative right leave will cover. And of course, it will just be those who are the main primary carers, where, for instance, the other primary carer who is not British or who hasn't got settled status in the UK may also not be able to remain with this child, because at every turn when you are making a 2.5 year leave to remain application, you have to consider the fact that you are taking care of this child as a primary carer, and that child will not be able to remain here if you do not have parental relationship or a genuine relationship with this child. So it is very important that people also make notes of the fact that it's not everyone with 2.5 year leave that will qualify under the Zambrano route. Yeah, so that's just a bit of update in terms of that.
Okay. Okay. Right. So, Lawyer Eunice, regarding today's topic,
Yes.
what is the reason behind this topic? If I should ask.
Okay, so I think that most of the time when we do have these programs and people like to ask questions and people like to know, for instance, you have people who previously used to live here who would always message me and always say, I want to come back into the UK. This and this happened and I had to leave, or this happened and I was removed. And can I return to the UK after um, whatever happened? And so I decided, you know what, it's better that I do a whole program on it to just educate people and make people aware. So that's why I did it.
Wow, amazing. Okay, so yes, what are some of the reasons under which an application or leave to enter or permission to enter the UK may be refused?
Okay, so usually when you make an application to say that you are coming into the UK, whether it's a student visa, a work permit visa, a visit visa, whatever visa that you may be applying for to come and, should I say, stay or reside in the UK, whether it's for a few months or for a number of years, that is usually an application for entry clearance, or um, that is an application where you are asking for leave to enter the UK. And usually with those applications, there is always the likelihood that if you don't meet certain requirements, it may be refused. And so, usually, as lawyers, we want to make sure that the facts and the circumstances of each and every case is in line with what the requirements under the law are. And so, of course, if you are saying that you are applying to come and live with your wife, for instance, and we are telling you that you have to meet the relationship requirement, you have to meet the English language requirement, you have to also meet the financial requirement and accommodation requirement before we can put in the application. And then also there's something called the suitability requirements. They want to make sure that you're not somebody who has previously been given a deportation order, or you haven't done anything where the Home Secretary has told you that you could be excluded from the UK, or for one reason or the other, you haven't deceived the Home Office or presented them with any false documentation, and the list goes on and on. So if you are able to meet those suitability requirements, then of course we can tell you that your application is on its way to get a good outcome. But if for one reason or the other you are not able to meet certain suitability requirements, or you have done something which under our immigration rules, specifically under Part 9, they will have reasons where you are saying that there are some certain things that you have done, or certain things that you could probably may not have put on your application form but has been found out, and therefore you are being told that your application can be refused, or even you've been granted leave to enter the UK and you come to the airport and they're telling you, we have found that beyond reasonable doubt, or we have found that your documents that you presented more likely than not is false, and therefore we would not allow you to enter the UK. So things like that, obviously, we need to make people aware that these are circumstances in which your leave could be either cancelled, or you could be refused an application to enter the UK if you fall under some of these circumstances. And therefore, it's important that you make the Home Office aware if there are certain things that have taken place, and if you have any mitigating circumstances, that you present all of those things to the Home Office so that they can assess correctly whether you should be somebody whose application is allowed or somebody who should be allowed to enter the UK. So it puts sort of a responsibility on the applicant as well, and not just the Home Office to prove certain things.
Okay. Now, you give a scenario whereby you get to the airport and you are told you will not be allowed, to enter the country, or possibly is it when you are leaving? A typical scenario: you're leaving Ghana to the UK. Is it at the airport in Ghana that you will be refused to, board the plane, or when you get to the UK, you are going to be told that your documents are false? If so, in such circumstances, what do you do at the airport? Do you return back and appeal? What do you do at that very moment? Or you call your solicitor to come to the airport and explain?
So usually what happens usually what will happen is that, of course, if you are traveling from your own country, you're not going to be questioned because it's your country of origin, and so nobody's going to be questioning you. What happens is that when you are entering into a country where you have a visa, so it's not your country of origin, and therefore you would have applied for a visa to enter that country, and they will do their necessary checks. So if it's the UK that you're coming to, of course, they will have to do their necessary checks just to find out, for instance, why you are coming here. And so sometimes it could be that you've even applied for an EU family permit or EUSS family permit. You are stopped at the immigration desk and you are asked a few questions, and they tell you, please wait, we will get one of our officers to question you further. And then, of course, they carry on questioning you, investigating why you're here, why you've been given the permits that you've been given. And it is such that, of course, and that those circumstances, you yourself, you're probably tired and worn out from a flight, and you are being interrogated um, for one reason or the other, because maybe they've noticed something on your application, or they've noticed something about you and they've called you to the side. So if you are in such a situation and they tell you that you are likely to be detained because, of course, they believe that you have presented false information, for instance, then I think that, of course, you need to phone to have legal representation. So when something like that happens, they would inform you as to what to even do at that point in time, and you can seek for legal representation. Of course, if you are not able to seek legal representation and they detain you for some time and they are able to get a flight back to where you're from, believe you me, they will put you on that flight until you have got legal representation. So, yes, in such circumstances, it's always good to get a legal rep to obviously put in some further representations, and then if the need be, of course, they would give you some temporary admission to be able to go home and um, be where you were supposed to be. So if it was a family member's place that you were going to reside, then you can go to that family member's place to have things sorted. Yeah.
Ali is asking in which circumstances would the Home Office definitely refuse your application or entry to the UK?
So usually you will have cases where, for instance, somebody was given a deportation order, and if that person was removed, or should I say deported from the UK, because they had committed a criminal offense for which they were given 12 months prison sentence or more, then that person's application to re-enter the UK is one of those ones that they would definitely refuse, because even though for one reason or the other, they would say that there has to be a time lapse of at least 10 years. So usually if you have been somebody who has been previously deported because of criminal offense and prison sentence that was given, they would say, okay, at least let 10 years pass from the time you were convicted or you were removed from the UK. And if you were to put in an application, sometimes if they are looking at it and committed an offense for which, for one reason or the other, they believe that they were very, should I say, very harmful in the offense that they committed, and there are other offenses that this person has committed, it is more likely than not that they will definitely refuse that application. Sometimes you will also have applications where the Home Office will tell you, we have proof that you definitely deceived the Home Office when you were making this application, or you used this false document when you were making this application, and therefore we are going to refuse your application because we have proof. We have gone out of our way to get proof that you definitely made a false representation, or you used false documentation, or you deceived the Home Office in one way or the other when you were making your application. And there will be instances where, for instance, if the person is saying that they were previously in the UK, they have breached some Home Office laws. So, for instance, in terms of coming to the UK, they had a visa which was valid for maybe 2 years. They continued to remain in the UK after the 2 years, so they became an overstayer. Of course, then that would mean that that person's application, if the time, of course, for which they have said they should wait until they remake an application is not due, they will refuse that application. So usually in such an instance where they have said to you, we know that you previously breached immigration laws. If you went of your own accord and you didn't use any Home Office expense, so there are some instances where the Home Office will give you some money to go back home, and those that do not take it, usually they have 12 months in which they can reapply. And then there are instances where the Home Office will actually pay for expenses and the rest of it. And in such cases, they will say you would have to wait about 2 years before reapplying to come back to the UK. So, of course, you have those specific instances, and hopefully, not many people will fall under those categories. So, that should be one of those ones where it's quite extreme, and so it should be okay if people are able to say that, hey, I know that I have had this issue before, but I would like to reapply and have my application be successful because I have been able to show that maybe I have done other things that show my good character, or I've done other things to show why that information was presented, which wasn't as serious as you said it was. Or now I've been able to show clearly that there has been time, that time period has now lapsed for which I can now make a new application to come and live in the UK. So obviously those circumstances are ones that are quite extreme.
Oh, okay. All right. Ladies and gentlemen, if you've just joined us, this is Heritage TV, hanging out with Vicky. And today we're discussing circumstances where persons can or may be refused permission to enter the UK or leave to enter council. As Lawyer Eunice was, explaining to us, some of the reasons may be because the person might have a criminal offense or may have, made false representation to the Home Office, or the person is in breach of immigration laws. If you want to contribute to this program, please do so on all our social media handles, especially Facebook, where we are live at Heritage TV, and also on BWF Solicitors Facebook page. We'll be able to pick all your questions, and my units will be able to answer those questions. If you prefer to call us live on this program, the number is 0744 8619 711. The number is 0744 8619 711. We will be expecting your questions and your phone calls. I believe that collectively, if you bring in your questions and you answer them, it really makes the program more interesting. So we will be expecting your questions and your phone calls during the show. I will also encourage you to share to all your friends, colleagues, and loved ones, and of course, anybody who this program will be of benefit to. Please share for others to hear or know what we are discussing today. Back to Lawyer Eunice. Lawyer Eunice, Amina has a question. She says, my brother left the UK in 2008. When he was convicted of a driving offense and was given some penalty points and fine, he would like to return to the UK, at least to see his son. He hasn't seen he hasn't seen in years. Can he make an application to come to the UK?
So you have a scenario where this person has committed an offense, and usually if the offense was committed and you were given something like a fine, or you were given penalty points or whatever it is, it's not an imprisonable offense, and so therefore maybe that was what he was given as a way of should I say a way of caution to say that, well, you shouldn't have done A, B, or C. And so in instances like that, that person is not somebody who is liable to deportation because they were not given a prison sentence. So sometimes people will be confused as to what's the difference between somebody who is deported and somebody who's removed. So somebody who is deported is usually a person who will have a criminal offense for which they have been given a prison sentence of at least 12 months or more. Whereas somebody who may be removed will be somebody who maybe has committed an offense, but then they didn't have that prison sentence, or they were given a non-custodial sentence. So usually it will be a fine, it will be community service or penalty points or whatever it is. And so in this instance, you have her brother who has been convicted of an offense, but then it was a non-custodial sentence that he was given. So he was given a fine and some points on his license. And maybe for one reason or the other, it's not very detailed. Maybe he was removed, maybe he left voluntarily. And so in a case like this, if he wants to make an application to come, it depends on what application he's making. Is it a visit application? Is it an application where he's saying that he is got parental responsibility for his child? And if so, that would mean that the other child's parents would have to be somebody who, for one reason or the other, is not British or is not settled here in the UK. And if they are British or settled here in the UK, then of course he can't make the application because of the requirements under Appendix FM of our immigration rules. Because the child has somebody who is able to care for them, and so in that sense, he wouldn't need another primary carer to come and care for him. So the best option might be that he applies for a visit visa. And if you look at our immigration rules in terms of Part 9 of our immigration rules, it talks specifically about where, for instance, a person has committed an offense and they were given a non custodial sentence. Um, they say that, of course, the application may be refused. So this is discretionary. So it's not, it will be refused. It may be refused unless you can show that, of course, since the non-custodial sentence he was given and removed, at least a period of 5 years has passed, and this person is somebody who is doing well. Maybe when he went to Ghana, he's been able to form some sort of community organization which helps maybe children, which helps the community. So he's able to present some form of letter in regards to that. Maybe he's got a good job when he went to Ghana, and so his employers can vouch for him and put it in a letter. He can show different things to show the fact that he's been of good character since he left the UK, and so he is making an application for a visit visa to come and see his son. And so, of course, if that is the case, then he can go ahead and make the application to come and see his son for maybe a period of 6 months. And so, of course, he has to make sure that he's putting in all those evidences so that when they look at the application, they see the reformed character that he is now, and the fact that maybe he may be somebody who actually has changed and should be granted a visit visa in terms of him coming to see his son. And so, yes, he can include all of those documentation, and hopefully they should grant him a visit visa to see his son.
Okay. All right. Another message. I think this guy wants to remain anonymous. He says, I was removed from the UK in 2010 after I was found to be working with someone else's documents. I was detained and sent on a flight back home. I would like to know if I can return after all these years. I think with this one, they usually give you a number of years that you can reapply and return. Am I right?
Yes, so this is an instance where he has been found out to be using somebody's documents. And in most cases, if you're using somebody's documents to work, that means that you yourself, you don't have any immigration status in the first place. So that means that he's definitely in breach of immigration laws in the UK. And like I was saying, an example is somebody who is an overstayer. And you usually have people who even come here illegally. So they may have come from Europe, went through the Dover port to come into the UK. I mean, there's so many instances where you come across people who have entered the UK illegally, and all of those are usually criminal offenses, and those are things that the Home Office will say you are in breach of their immigration laws. And so, in instances like that, where you are saying that, yes, I was removed from the UK, and he says he was removed in 2010. and therefore he wants to know if he can come back to the UK. If he was removed and they gave him something, so they gave him some money to be able to set something up and do something for himself. It's I mean, I don't know whether to say the home office are generous in that sense, but once once you tell them you want to leave their country, um, they can actually pay for your expenses, your flights, and give you money to set something up when you go back home. And so, if
Yeah.
it was something that he obviously returned by the state's pockets, and so his expenses and everything was paid for, then that means that, of course, he will have that period of 2 years to be able to make an application. And if he did return on his own accord, and there was nothing given to him whatsoever, and then, of course, he would have been able to make the application after a year or 12 months. So him being there for a period of 10 years, obviously,
Yeah.
that goes to show that maybe he was not aware of the time period, or maybe he was busy with other things, and so he had to make sure that those things were well taken care of. So yes, he can make an application at any point in time, because the time period for which they would usually say that he's not supposed to return to the UK would be 2 years, or if he went on his own accord without any funds from the public purse or the public pocket, then he would have been able to make an application after 12 months of leaving the UK.
Okay. All right. Wow. I'm just trying to pick up some more questions. I think there's one, Emmanuel and Sylvie.
Okay.
He says, can one have been refused application for 2 consecutive points, be banned for 10 years from the UK without forging any documentation?
Okay, so in regards to Emmanuel's question, usually the only reason why they would refuse an application and give you an automatic ban for 10 years would be if you were somebody who made an application, for instance, and you didn't disclose certain information. So maybe there was certain information that was on the form. So they asked you, have you ever made an application to the UK? You know you have, and it was refused, and you said no. So, in an instance like that, where you were supposed to disclose certain information and you didn't disclose that information, that is seen as deception. And so, the Home Office takes it quite seriously. And if they believe, or they have proof beyond reasonable doubt, that you did deceive them in making this application, then of course it's an automatic refusal. And then of course, if even if they don't have proof, the immigration rules, they may refuse your application if, with or without your knowledge, certain information was put forward to them, or you did not disclose certain information to them. And so, not putting the information down and then putting information down which is also false is no excuse to them. They are both seen as deception. So yes, Mr. Emmanuel,
Right.
they can refuse your application and give you an automatic ban of 10 years if they believe that there was certain information you were supposed to disclose to them which was not disclosed, or there was information that you put forward which they believe to be false. But in his case, he says that there was no false documentation. So false documentation is separate from false information. So you can put information on the form which could be false and may have presented genuine documents for the application, or you could have omitted certain information from the application which they would deem to be important, and you did not put that information on the form. And so if they refuse the application, they may give you automatic ban of 10 years. Yeah.
Oh, okay. So putting false information on your application form and forging, I think forging has a higher punishment than...
Not necessarily. So if you put false information on your application, or if it is believed that you put forward some false documentation, they all hold the same weight because they see it as deception. Whether it was false information, false documentation, or some false representation, they see it all as deception. So if you have deceived them in one way or the other, they can give you an automatic ban of 10 years. So usually, like the question I put forward, so they ask you, have you ever made an application to the UK or to any other country? And then you said no. And probably because maybe you are not the person filling in the form. And so the person who was filling in the form for you didn't know and put no when it should have been yes. You've been refused application before. That is definitely seen as deception. And so, of course, they don't care whether it was to your knowledge or not. Because you answered yes, no, instead of saying yes, it is seen as deception. So it doesn't matter whether it was a false document or false information or not even disclosing information which they deem to be relevant.
Okay. Now, Eunice, what is the minimum or maximum years of one being banned or refused to enter?
It depends what the person did. So in this instance, if it was deception, then usually they would say that you have an automatic ban of 10 years. Or if you were deported, they would say that you have to have been removed, and then 10 years must pass from which time you can put in an application. Or for instance, if for one reason or the other you were in breach of some immigration rules and they thought, do you know what, because you have been in breach of our immigration rules, a period of 12 months has to pass before you can re-enter the UK. But if you went and we paid for your expenses and the rest of it, then 2 years has to pass, from which time we would then look at any application that you have submitted. So it differs depending on the circumstances. So
like,
if
you've been in prison.
Yeah, so if it's an imprisonable offense where you have been there for a period of 12 months or more, usually they would say that you should have been out of the UK, or from 10 years from the time you left the UK is when you can reapply to enter the UK once again. So it's important that, of course, if, for instance, I gave in the other scenario where the person has said, do you know what, I committed this offense, I wasn't given an imprisonable offense, an imprisonable sentence, and I was given maybe a fine, or I was given a non-custodial sentence, and therefore I want to come into the UK again. Usually in that instance, if at least 5 years has passed from that time, then that person can reapply to come back to the UK.
All right. Okay. Right. Okay, ladies and gentlemen, if you just joined us, this is the Legal Hour Show on Heritage TV. I'm your host, Vicky, and with me is Mrs. Eunice Achampong, a solicitor and partner at BWF Solicitors. Today we've been discussing circumstances where persons can or may be refused permission to enter the UK or leave to enter cancelled. And we've got viewers sending in their questions. Answering those questions. And may I also remind you that whatever is being discussed here is for information purposes. So if you decide to make an application or this discussion applies to you and you believe that you need the services of a solicitor, just don't take this discussion to go ahead and put in your application by yourself. seek legal advice from people like BWF Solicitors, and they'll be able to help you with your application process. Laura Eunice,
I was just going to say that Emmanuel came back with a follow-up. He says,
all right, okay.
Thanks a lot. If you have been given such automatic ban, will the Home Office give you any letter to inform you about that ban? I was going to say that usually, once they refuse the application, they will write it in the refusal letter.
Okay.
So, for instance, if you've made an application and they believe that deception was used, and they do that a lot with visa applications where information has not been disclosed. So, if you said, of course, that you didn't have that information at hand or whatever it is, and they refuse your application, they will usually write in the refusal letter that because they believe that you use deception, and therefore they have given you an automatic ban of 10 years, and you will not be able to put in an application until, so for instance, we are in 2021, so you will not be able to put in an application until 2031, and they will state it quite clearly in the refusal letter.
Okay, and really, this one thing came to mind. Right, if you have been in breach, like you've given us all those instances, and I decide to make that application after 10 years.
Yes.
What is the guarantee that I'll be allowed back into the UK? Because I believe that being banned is a form of punishment.
Yeah.
But the question is, how will the Home Office be convinced that you've turned a new leaf, and therefore when you are allowed to enter the UK, those offences will not be repeated again?
Yes, and so I think in that instance, where, for instance, if you look at part 9 of our immigration rules, yes, they would tell you that you have to have a period of, let's say, 12 months past, or you have to have a period of 10 years past, or a period of 5 years past. But there is the likelihood that they could still refuse your application. So there's the discretionary refusal, and then there is the should I say mandatory refusal, where if, for instance, 10 years has not come to pass since your criminal record or since your automatic ban, they will definitely refuse the application. But if that time has lapsed and you are still making the application, there is the likelihood that they still may refuse the application. So you are not out of the woods as yet. So you are having to prove to them that, for instance, if you have been in breach of immigration rules and you came to live in the UK illegally, of course, for instance, somebody who is making an application, a spousal application, to come back to the UK. Previously, if you were somebody who was an overstayer and you went back to whichever country you were from and you wanted to make the application to join your spouse, that automatic ban of, let's say, 12 months, it wouldn't have been applicable to you because you are coming to the UK to join your family member who is British. And so it was so simple. But since the 1st of December 2020, if you are making such an application and you haven't been able to show, for instance, that you have let that 12 months lapse since you left the UK, they would refuse the application. But if you are able to show that, of course, you have this genuine relationship with your partner or your spouse, and maybe you have a child together and you have a genuine relationship with that child as well, of course, then they can say that, well, at least you've been able to show evidence of your family life with your spouse or your partner and the child. And so, having seen that, we are going to grant your leave to enter application. Or somebody who is coming just on a visit visa and they want to be somebody who is saying to the Home Office, yes, I came to stay in the UK illegally for this period of time. I just want to come on a visit to see A, B, and C. Maybe time within that time they've been involved in other things. They've maybe set up their own business. They've done things, as I said before, within the community. Now they have new roles that they are, should I say, they are in now, and therefore they want to show that they have become more responsible and more, should I say, people of good character within the community, and therefore they want the Home Office to look at their case favorably. And you will have to present all of these things. And usually we say that even with visit applications, if you can't show that your visit is genuine and that you will not come and stay in the UK after your period of visits, it is likely that even that will be refused. And so a lot of work goes into giving that evidence that you are now somebody who could be seen as somebody who is genuine and has changed or reformed since you last came to the UK. So it's more to do with the evidence that you can present as well in meeting those requirements.
Okay, so Laura Eunice, can one appeal such cases? Putting in an application and being refused again. Is there any, and how many times can you appeal?
So, of course, if you were putting in an application, let's say for a spousal application or a human rights application, or for one reason or the other, some people would have been putting in student visa application or work permit visa application. Of course, with those ones, if you haven't got any human rights on which you are saying that you are coming to live here in the UK, because of the fact that our Nationality and Immigration and Asylum Act was changed to reflect that now you can only have a right of appeal if you can show that there are human rights basis for which your application was refused, or that you are a family member of an EA national, or that there are humanitarian grounds, or you have refugee status. Those applications usually would not come with a right of appeal. So if you were making an application, let's say for a visit visa, for instance, it wouldn't usually come with the right of appeal. It would just be refused. And so it would mean that you will have to find a basis to say that maybe your visit visa was on the basis that you were coming to see a family member who you haven't seen in a long time and you genuinely have a relationship, let's say, with that family member. So in the instance of the man who said he was coming to see his son, if he was making a visit application and for one reason or the other it was refused, he will have to obviously go down the route of judicial review, for instance, if he is able to show that there was family life with that son of his. Most people would put in an application again, but if you genuinely believe that the Home Office was wrong in their decision, then you can obviously seek legal advice and they will take you down the judicial review route.
Oh, okay. All right. Brilliant. Brilliant. Wow. Okay. Right. I think. Right. Okay. All right. This person wants to remain anonymous. I applied for a visit visa, and when I reached Heathrow Airport last year, I was stopped by immigration officers and questioned. They found documents to do with my work in Nigeria in my handbag. They detained me because they said the answers I gave did not correspond with the answers on my application. I was returned on the next available flight. Can I make another visit application?
So this is a case where, for instance, he's saying that um, he's obviously made an application, he's been questioned, and after questioning, they believe that some of the information maybe he gave did didn't have anything to do with the answers he gave on his application form, and therefore they returned him back home. Of course, if you are making an application to enter the UK, I believe that most people may have help in making these applications and they will not do it by themselves. So it is important that, as much as possible, if you had help making this application, please get a copy of the application that was made for you. It's always good to have information. So if it's your application that was made, get a copy, see what information was put down on your application form, just in case when you come and you are questioned, you will know what was put down. So have a copy of the application that was made for you and know what information was put down for you. And also, it is important to also know that sometimes they may put on there certain information and present certain documents to you. And you should know what documents were used in line with your application. So you shouldn't just say that, oh, you just took some documents and presented it at your visa application center, but you should be able to have an idea as to the documentation or the evidence that was presented when you were submitting your application. So all these things are important. So in relation to this question, if for one reason or the other he is saying that he was returned back to Nigeria because of the fact that they believe that the information he presented to them during the interview was false, and therefore they think that he has he has deceived the Home Office in one way or the other, then it is up to him to make sure that there wasn't an intention to deceive. So there's a difference between there being a misrepresentation and then you saying that there was that intention to deceive the Home Office. And so, of course, if they think that it is more likely than not that he presented them with false information and they have returned him to his country where he's from, then the next time when he's making an application, which should usually be at least some time after the period that he's gone back. So if they said, we are letting you return back to Nigeria, and they give him a notice that he's liable for removal, and of course, if they have said categorically that we believe that you've made some false representations to us whilst you were questioned and it's not in correspondence with the information on your application, and we think that you should leave on the next available flight out of the UK. In that instance, he would not have been given an automatic ban of 10 years, let's say, as some would have received in their refusal letters. So if you haven't received that automatic ban of 10 years and they believe that in due course, of course, if you were to make this application, you should be able to explain your intentions. Did you actually want us to believe the information that you gave to us during the interview, or was it that because of your flight and fatigue and the rest of it, some of the information may have been distorted? So they want to know if your intention was to deceive them in that process. And if you are able to show that, of course, the information you gave was based on A, B, and C, and you did not intend for any reason to give them any information that would be, at least, should I say, completely opposite to the information that you were given to them on the application form, then at least that helps them in assessing whether they should grant you another visit visa or not. And so it's important that you are able to show them as much as possible that there was no intention to deceive them in terms of the answers you gave, or in terms of the answers you put forward to them in your application. So it's very important that you seek legal advice when you are dealing with such situations.
Okay. All right. Okay. In the absence of any further questions, Maria Ines, if you can quickly round up what we discussed so far, and if someone is watching and wants to contact you for advice and help, I'll be glad if you could also give us your contact details and office address.
Emmanuel keeps coming back with questions.
Oh, okay.
Yes, so he says, please, madam, what documents will one need to apply for UK visa without refusal? I need your help. He doesn't really specify what application. He just says UK visa where there has been no refusal. So if there hasn't been any refusal whatsoever previously, and the person wants to make another application to come to the UK, it would depend on the visa type the person is looking to apply to. So if it's a partner or spousal visa, or a parent visa, or a visit visa, there are requirements for each category or each visa route that a person can apply to. And so they should be able to meet those requirements to be able to make the application. And so, as I said at the beginning, there are certain requirements and there are certain suitability requirements that have to be met. And if um, the person is able to meet those requirements, then they are definitely looking forward to a successful outcome. So, in terms of that question, I'm not sure which visa the person wants to apply for. So, depending on the visa they want to apply for, then of course we can look at their circumstances and whether they meet the requirements.
Exactly.
And then if they do meet the requirements, then we can specify which documents need to be included in terms of that application. So definitely, if it's one of those visa applications, then they can make the application with evidence that this is their circumstance in the country of origin, and they are just coming on a visit. Maybe they've given them work leave of at least 2 weeks, and they're telling them this person is off work for 2 weeks. He just wants to come on a visit and return, and the rest of it. So, of course, he's also said that in his refusal letter there was no automatic ban stated, but it was based on a balance of probabilities. Bank statement can do, because I was refused in 2015 March, and my brothers are there and want me to join them there. And we've tried several ways, but I still got refused. So
I think the best way to go about it is for Emmanuel
to call
you, but you leave in your contact details.
Yes.
And probably you guys can, he can take it from
there. Yeah.
With him with what
he needs to do. Definitely.
Make application successful. Yeah.
Yeah. So Emmanuel, definitely give us a call, or you can contact me straight after the program, and then obviously we can take it from there. And so yes, if anybody has heard anything that I've spoken about today and feels that they are currently in a situation like this and they need help in terms of making applications to enter the UK, of course, you can do so. by giving me a call after the program on 075 35 81 3910. And I am also a solicitor at BWF Solicitors, and our offices open from Monday to Friday, 9:30 a.m. to 6 p.m. Our offices are situated on the fourth floor of Anna House. So fourth floor of Anna House, 214 to 218 Tottenham High Road, London. Our postcode is N154NP. So N154NP. And our office telephone number is 0208 493 7340. So 0208 493 7340.
Thank you, Eunice. I want to also ask you one. I think this question can be, may sound funny, but for the benefit of those who are on a restricted visa, what advice can you give such people or anybody else to prevent them falling into such situations?
When you say restricted visa, are you talking about like a visa?
I mean, if the person, like those who have 2.5 years have to be renewing from time to time, and those who have, indefinite leave to remain. Sometimes it depends on the severity of the, the crime that you have committed, and they can report you and take your revoke your illegal leave to
your leave to remain.
Sorry, to remain.
Okay.
Anybody in any situations.
Okay, so yeah. So obviously, as the topic was centered around those who want to enter into the UK, yeah. So those people, of course, if they find themselves in such situations, of course, they just have to go by the timelines that have been given and then make the application when it's due. But of course, like I said, when you're making the application, you definitely need to add evidence of mitigating factors, just so that they know that this is somebody who is reformed, this is somebody who has now been able to show good character, they now have family life and they are more responsible and they are able to organize and keep things going. So you need to be able to show certain mitigating factors when you are resubmitting an application of any kind to re-enter the UK. So of course, there's nothing you can do about it when it's already been given. So if there is anything like that, then you should be able to see how best you can rectify, or you can basically give them more information as to how they should assess your application and then grant you leave to enter. Yeah.
Because this question was just asked by Zaki.
Oh,
so
okay.
That was why I just put it there. So thank you for that.
Yeah.
Ladies and gentlemen, we've come to the end of this very educative program. I would like to take this opportunity to thank all my sponsors and BWF Solicitors, your number one immigration law firm in London. The whole of UK as a whole. Also to Victon Estates Limited, your number one property management company. You can contact them on 0744 861 9711 for all your property queries and needs. And lastly, Heights International School is a center for excellent mathematics teaching and learning. The subjects that they provide is mathematics and science for A-level mathematics, GCSE mathematics, GCSE further additional mathematics, GCSE statistics, and 13 plus mathematics, and 13 plus GCSE science. They've got excellent reviews. You can contact them on 0773 2202 The number again is 0773 2202 and their next academic date reopening is on the 11th of September. So I will entreat you to contact them as soon as possible, because during September they might have limited spaces. So get in touch with them and they'll be very happy to assist you. On that wonderful note, I must lastly thank my director, producer, Mr. Andy Thomas and team behind the scenes, making it possible for us to come to you live. I appreciate you so much. Lawyer Eunice.
Hello.
Yes, so you're definitely going to be with us next week, Saturday, same time.
Yes, God willing.
Yes?
Yes.
As you always do. So definitely we'll be looking forward to that with another interesting topic. So on that note, with me and Lawyer Eunice, we say goodbye and have a lovely weekend. Stay blessed. Bye-bye.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF Solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.